this segment, I want to talk about the four democratic principles and how they relate to American history in a brief overview. I've discussed that we have a constitutional democratic system based on four principles: majority rule, minority rights, freedom of expression, and the rule of law. And I've now given individual segments on each of those subjects, including two on the subject of the rule of law itself. Let me try to tie these together in terms of American history. In American history, one of the most significant events was the American Revolution. And that American Revolution is often portrayed today as if it were a revolution in which democratic forces sought to replace a monarch. That is the result. A monarch was replaced by a democratic system. But it's a little too simple to say that that's what they set out to do. Because, in fact, if you read the historical record more carefully, there was something else going on. It was, first of all, not a call for majority rule democracy. It was a call for a constitutional democracy. That's why, by 1789, we had a new constitution in place, and we're electing officials for a constitutional democratic government, not simply some kind of democracy where majority rule prevailed. How did this work? Well, critical to this statement was the importance of the rule of law, because the rule of law was already a value, a cultural value, and a political value, both for the people who lived in Great Britain and the people who lived in the British colonies in America. They already had a notion of the rule of law as the dominant way to run the government. And oftentimes, Britain spoke of itself as having a constitutional government, not a government run by a monarch. It had a monarch, but there was also a parliament, and there were also independent courts. So it was a constitutional regime. They already knew and understood the idea of the rule of law. Indeed, they already had a primitive notion of judicial review based on the writings, not quite dominant, but still very important in the British legal system, based on the work of a man named Coke, spelled Coke, but he had put the notion of the rule of law, the law over even the monarch, into the British system. So this idea of the rule of law was there. What went wrong? What went wrong is the British Parliament sought to change the rules without the colonies' consent. The colonies called it taxation without representation. To 20th and 21st century usages, that sounds like they were just calling for democracy. They just wanted majority rule, and that's all it was, but not known of. What was in the minds of the American colonists who first protested the new laws passed by Parliament, and what was in the minds of defenders of the colonies, people like Edmund Burke, in the Parliament in Britain, was the notion that there was a rule of law principle that said you had to have prior announcement. You had to let people know ahead of time. And if you had let them know that they were going to have autonomy in the writing of tax laws, you had to obtain their consent before you changed that. That's a rule of law principle. That's not a democracy principle. Indeed, the colonies were not particularly democratic, even after the American Revolution. They limited the franchise to males only who had wealth. Not very democratic there. They didn't have that notion in mind. They had in mind a rule of law principle. And in the minds of the colonists, it was the Parliament in Britain and the monarch in Britain who were violating the rule of law by imposing a tax without their consent and without their representation. That's different from a flat call for democracy. Now, the next step in this process is to understand that in the course of the revolution being fought, the ideas of democracy, the ideas of expanding the franchise were made. And by the end of the Revolutionary War, the democratic forces, those people who wanted to talk about democracy more than about the rule of law, had made real inroads. So the first reaction was to try to preserve these democratic practices, so-called, with a new document. And the document they adopted was the Articles of Confederation, Technically, the Articles of Confederation were drafted almost at the same time as the Declaration of Independence and were put into effect even before the war had won. But they only really had practical effect after the peace treaty in 1783, when the Articles of Confederation operated in America. The Articles of Confederation were a very loosely structured document. One might call it a democratic document, because people were free to do what they wanted. But it was not a good rule of law document, and therein was its defect. Most often we're told that the Articles of Confederation failed because they lacked an executive. But they did have an executive. They had an executive committee, and one of those members was appointed the president. So there was an executive authority, and that's not what was missing in the Articles of Confederation. There was also a legislature. The legislature had a problem, though. It could only vote by unanimous consent. So any one state that refused to go along with, say, a tax measure could defeat any new tax measure. That was an application of minority rights to an excessive degree, because it's almost impossible to pass any tax measure as a unanimous measure. Someone will always object. And if it's 13 states, one of the states is likely to object. So the Articles of Confederation didn't work largely on rule of law grounds. And finally, and most importantly, there was no court system. There was a committee in the legislature held to discuss problems that arose between the applications of courts in one state and another, but nobody could be at a definitive conclusion. So the Articles of Confederation failed by failing to give a federal court system. Now, all three of these limitations of the Articles of Confederation were repaired by the U.S. Constitution, drafted in the summer of 1787 and put into effect by the spring of 1789. The way in which it was ratified said that not all 13 states needed to ratify it. And indeed, by the time George Washington took his oath of office as the first president of the United States under the U.S. Constitution, not all the states had ratified it. It took Rhode Island until 1791 to ratify it and join the Union. In this case, then, what we had was a document, the U.S. Constitution, that was superior on rule of law grounds to the Articles of Confederation. And the fact that it was adopted says, once again, that while democracy, sometimes identified as majority rule, was one of the principles, it was not the only principle. I repeat again what I said before. In the United States, we have a constitutional democratic regime. It is a majority rule regime only in the sense that the American people support a constitution by a majority vote on a constitution. They do, and have consistently for 230 years. But that document that they approve of is one that guarantees a variety of minority rights. And those minority rights erode the majority's ability to make decisions on their own. We have both majority rule and minority rights. Among those minority rights, a critical right is the freedom of expression, which guarantees every person a right of expression, even if every other person in the world disagrees with them. Now, it is not a right to do things, so there are limits on how much you can do while expressing your idea, but you have a right to express the idea in some form. Finally, and preeminently, what is required for a constitutional democratic regime is the rule of law. The notion that the law governs the people, and the law governs all of its government officials. That disputes that question whether the government officials have done their job should be submitted to an independent judiciary, which is protected by a variety of provisions. And then, when law is imposed, that law be knowable and legitimate, that it be predictable, formal, general, equal, and somehow conforming to the underlying cultural realities of the society.